so to speak. Now, what's going to happen is we're going to send in our notice of appeal. I'll get that to you by Monday because she just made her stupid decision recently, which means the judgment will construe that as a final judgment. So you'll have a notice of appeal by Monday, okay? And that will go to the appeals court. You'll have to pay the filing fee because this is important. Remember, the bank came in and took the property, or the so-called realtor came in and took the property before securing the certificate of satisfaction. I mean, not certificate of satisfaction, the stupid certificate of possession, the writ of possession. They can't do that. They don't have the right to do that. So we'll do the appeal to get their attention, reminding them that they didn't have the right to do that. I want you I believe my system is doing some things in the background. I want you to understand that there are a lot of people who don't really appreciate the information. So we're going to do the best we can. I know what's causing my interference. Give me a second. I have to shut down something because right now I'm putting up a video, a simple video. What I want you to do is I just want you to understand the fight is not over. We're going to go after, and that's what we're going to talk about today. So you're going to see why the fight isn't over for any of you. Okay? We're going to talk about it today. And we're going to let you guys know how to just keep things simple in the court. We've been, and people like me, we're so used to doing all of the detailed stuff. So when we go into court, I'm used to putting in all of the paperwork. The kitchen sink, the fire truck, I'm used to putting in everything. And we need to correct that because you guys are not us. You guys are not savvy when it comes to the courts. So there's no reason for you all to be putting all this case law in your paperwork in your documents. And so people like me have to stop introducing all of that. Because you guys, you won't know what to say in court once you get our documents. So we're going to start not being so detailed. We're going to give you guys the basic information so that you can work off of that information. All right, now there's only three of us total here in this call so far, but we are going to get started on time and I'll be sending out a copy. And this is a weekday. So I don't expect a lot of people because even Jennifer, she's before the bankruptcy court. Oh, we're going to talk about how you guys should be going into bankruptcy court in the future. And when you do it for the estate, you know how sometimes the court is blocking you from filing bankruptcy on behalf of the estate? Well, we're going to show you how to get around that stupidity. So we'll be talking about that in just a moment. I am thinking, but let me call Kyle because I want him to be on this call this morning. He may or may not be available, but I'm going to call him nonetheless. So give me 1 second.
Yes, sir.
Mr. Kyle, I'd like for you to join us on that Skype call.
What Skype call?
The one that's supposed to be scheduled for today. You didn't get the email last week?
I don't think I did. I'm having internet issues at this moment.
Sure you are. I believe you.
It's just on this computer.
Well, no, we're starting now. So what you can do is, if you're not able to get on, I'm recording the call, but they can hear what we're talking about because they're eavesdroppers. So I'm going to have to get off the phone with you to go back and speak with the eavesdroppers.
Okay, Skype?
No, we're chiming.
Okay, regular subcontractors?
No, this is, okay, get a pen. No, just get a pen. Get a pen. I'll give you the number. 8084-20-3391. All right. All right. I'll talk to you in a minute. Okay. Goodbye. All right. Ladies and gentlemen, Patra, *7. You're on your phone, so you have to hit *7. And now we have also Mr. McCoy. All right, ladies and gentlemen, we'll be getting started now.
Hello?
Yes, no. I was just saying your name. We're gonna get started now. There won't be a lot of people on the call today because it is a weekday, and it is the weekday before the so-called holiday, and then we got that Black Friday holiday coming up because Black Friday is a holiday. If there was a holiday that I would celebrate, it would probably be Black Friday, but I am not materialistic, at least I don't believe I am, so there's nothing out there I want. I will be doing the internet shopping spree on Monday for Black Monday, so I'll be doing the internet one, but I won't be doing Black Friday. So that being the case, let me tell you guys what's going on. I just put up a video. As a matter of fact, it's being put up now. And I'm going to share my screen. Now, the problem with sharing my screen these days is that a lot of system resources are utilized. This video is called What is Your Identity? Bankruptcy Court, and let's get the full title. And getting your file. Now, this is not your IRS file. That's a different file. But these are the things we're going to talk about this morning, so that all of you are aware. First, many of you have been going into bankruptcy court. We've been going into bankruptcy court the wrong way. What's the correct way of going into bankruptcy court? I just did a video earlier this morning, and we're going to open up this web browser, and that video took us to this site right here. Now, this is irs.gov. When you go to irs.gov, you want to hit apply for an EIN number. So when you get to apply for an EIN number, it's going to take you to not this screen because it says my session has expired. It's going to take you to a screen, and the very first screen you get to, come on IRS, what's wrong with you? It's going to give you this information telling you that you need authorization to be on this screen. For now, everybody mute yourselves. And you're going to go to this screen and you're going to click Begin Application. Once you click Begin Application, it's going to take you to this screen. You're going to go all the way to the bottom. Do not worry about all those other little things up here. That's not your concern for the purposes of bankruptcy. You're going to click on the very bottom, View Additional Types. You're going to click on the very first one, so last then first, okay? It says Creating a Bankruptcy Estate EIN. It says individual. Do not focus on the word individual. That's not important. Then you're going to click on Continue. When you click on Continue, you're going to click on Continue again. Do not worry about the information in the middle. We're not concerned about that, okay? This is filing bankruptcy under Chapter 13. I'm sorry, I got to go back because we do have to go back. You still get the same EIN number if you go here, but I want the other EIN number. Look at that, it wouldn't even let me go back. Shame on you, IRS. Yep, it won't let me go back. Oh well. Anyway, you can do it there or do it here. It says, please tell us about the bankruptcy individual. Oh, I'm sorry. I read wrong. I apologize. It's my fault. This is Chapter 7, Chapter 13. It says if you are filing under Chapter 12 or 13. So we're not worried about Chapter 12 or 13 right now. Okay, we are Chapter 11 and Chapter 7. You're going to put in the information, first name, last name, social security number. Yes, your social security number. It has nothing to do with anything. It's only so you can acquire the number. So you'll put in the first name, last name, social security number. For those of you who have already done this, it's fine. You don't have to do it again. But for those of you who have not done this, this is how you create an EIN for your entity. Okay, so it sent me back to the first page. So everything was right. You click on Begin Application, and you click on the very bottom, View Additional Types, and then you click on the very top when that page pops up. Sorry, I'm tethering, I'm on Skype, and I'm also putting up a video, so I am working my internet. Then you get back to this page, you hit Continue, and we don't need to change type because we're right where we should be. Okay, and you fill this out, and you go through the process. I've already done it, so I can't do it again. Okay, you fill out this, it will take you through the process. Now, some of you, let me take a look at my Chime. Okay, where are you, Chime? Some of the individuals here are on their telephone. If you're on your cell phone and you came in through the Chime application, you'll be able to see my screen because it'll give you the option to view the screen. If you came in just by telephone, then you won't be able to view the screen, but all of you will get a copy of the video. You'll be able to see everything that I'm doing. I am recording. Okay, let's get back to this. Once you create this, then you will go to BKFORM 201. It's going to be the bankruptcy form, and these are the bankruptcy forms. We might as well go to all of them. This says voluntary petition for non-individual. You are going to download the voluntary petition for non-individual. Some of you are going to realize this is not all of the forms. They're going to tell you they need a complete blah, blah, blah. People like Miss Cynthia Moya, this is information you guys need to know. So what I'm going to do is I'm going to save this file. So that's what I need is my save button up there. And I'm going to save this. Yeah, we can put this in my bankruptcy filing section. And now I'm going to go and open that particular file. Give me a moment. That's YouTube. Mute yourself, please. Okay. Now we're going to open up this document in our PDF Exchange. All of you should have received a copy of PDF Exchange right now. This says for Florida. Now this is not the form I need. This is somebody else who filed a non-individual bankruptcy. So what I'm going to do, I'm actually glad I pulled this up by mistake, ladies and gentlemen, because many of you need to know how to fill these forms out. And here's an attorney who filled it out for a company. And so here is your how to fill it out, what to put here, what to put there. If you want to do all of that, this is a complete filing for a company. Okay? And this was done 5 of 2016, so May of 2016. So here is your example of how to fill it out. Now this one says it's a diversified bankruptcy, okay? Because that's a special, diversified asset recovery. Wait a minute, diversified asset recovery is filing for bankruptcy? Does anybody know who diversified asset recovery is? Diversified asset recovery is a debt collector. And they filed for bankruptcy. That is interesting. Okay, so these are the schedules. These are the forms that you're going to download. You're going to do the same thing as diversified asset recovery. Remember, you are the only creditor, but you need to know who you are. So I'm going to send this, I'm putting this in the Chime chat section, and then I'll send it out in email later. But because I'm putting it in Chime, it wouldn't let me drag and drop. Let's attach. Let's go documents. Okay, that's going to be your sample example. For those of you who need to follow, that's what you're going to follow. Okay? And this meeting won't last that long. My job is to get you all back to your lives as soon as possible. Leave you up. I got to download the correct bankruptcy form first. Knew something was wrong because it was 27 pages. The actual bankruptcy paperwork is about 4 to 5 pages. So this is the official form. See, it says official form voluntary, but this is the actual, it had a case number and I should have recognized that. So we're going to go 201, the official form. And this one should be just a blank form, no written anything in it. But I'm actually glad I downloaded the 201 from the attorney, because now I can do a video showing other people that they can do the same thing. As long as, and you know, I do need to have my chime up so I can see when my voice is not showing up when I am read out, because that means that if it shows up red, that means you guys can't hear me. Nope, this is another filing for another company. I'm gonna download it anyway. I don't know why it's saying official form and it's not the official form. And I don't know why it's not giving me the option of copy. There we go. Yeah, that makes no sense because it's not giving me Payless. Interesting. Payless Shoe Store or Payless Holdings has filed for bankruptcy. Would never have known it if I hadn't done this. This is a voluntary petition for individuals. We want 201. So I'm going to go to the BK forms and get the 201 because apparently all of those PDFs are for corporations. Now, the 201 is for corporations, but many of you are having problems because they're telling you when you come in as an estate, you must be represented by an attorney. The attorney must be represented, the estate must be represented by an attorney. Many of you have heard that. What I'm going to give you is your way around that. Estate must be represented by an attorney. Okay, so we're going to click on this one, which is voluntary petition for non-individual. And don't care about no committee notes. We just want the form. It takes us here. This is the form we're looking for. I'm going to put this in the chime so that you guys will have a copy. Give me a second to save it first and then put it in there, and then we're going to talk about this particular form. Okay. Do that. I will, so that you guys will have several samples, examples, I'm going to put in all three. We already put in the first one, diversified, and we're going to put in Payless, and oh, it won't let me do two at a time. So do that one and one more. We're going to do the actual empty form. So those of you who don't know how to get the form, you double click and it will start to download. Okay, that's how you get the form out of the Chime chat, but I will be putting it in the email that I send to all of the people along with the video later today. Let's go back to opening up that form so I can tell you how to fill it out. Like I said, a lot of people, get rid of you, and go back here. Huh, it's supposed to be here. Let's do that again. There we go. All right, on this form, all the rest is self-explanatory, but when you put, let's put the debtor's name, so we want select text. Let's see. When you put the name, nope, it's not letting me do it that way, so I have to do it my way. Let's get rid of some things. Name, then you put the name, you put non-individual, and you guys are going to be using, if you're using PDF Exchange, as I told you, PDF Exchange is going to come in real handy, but it ain't supposed to have a line through it, so I see why I put that line. And that's me because of rushing this, so you don't need a line, but you're going to put the name and you're going to put non-individual. okay? And my suggestion, put the last name first name, then middle name. Matter of fact, I'll even do that for you guys. Let's do the highlight, and and you'll have to open this up in PDF Exchange so that you can take away the highlight, because as long as it's PDF Exchange, you'll be able to take away the highlight. Let's do the whole thing. All right. You're gonna put, oh, can't do that. Don't want to do that. Give me 1 second. Here. Last name, then comma first, then middle. Okay, you don't have to put estate, you don't have to put grandmama, you don't have to put grandpapa, you don't have to put any of that. Okay, the only thing you're gonna do, last name first name, and then middle name. Okay, and I'll just do it that way so you'll understand. Well, yeah, let's do it the right way. Okay, that's how you're going to fill out that top section. And we don't care about other names the debtor has used because they're doing corporations. We only care that this is a non-individual. It is a voluntary petition for non-individual filing. So when you're standing there before the trustee, you're going to just simply say, oh, I'm here to represent the non-individual. The non-individual is the debtor. Now, if you have to explain, you're going to tell them, oh, the non-individual is a state agency. It's a vessel. And just use the word vessel because they understand that term. I can't go in and argue for you, but you have to understand this. This is because you don't want a bankruptcy appearing on your credit report. By the way, the new law says you can get bankruptcies removed from your credit report because it is not an actual public filing, not an actual public record. Then you put that EIN number you got from there, and the rest is self-explanatory. Ladies and gentlemen, if you have a P.O. box, have them communicate with you through the P.O. box. Do not have them communicate with you through the street address. Okay? And the reason why the debtor is first, last, first, middle, because when you put your name as the creditor, this is the reason why you get to do this, ladies and gentlemen, because on government forms, when your name is in all caps, even though you receive a driver's license with the name first, middle, last, on their official forms, it is last name, first name, middle name. That's how they identify you on their official forms. So this is how you're going to identify yourself in a way that they understand. They will sit up there and pretend they don't know what you're doing, they don't know what you're talking about. That is all a lie. Okay? They know exactly what this is. They know exactly how your name appears. I would not have known it if I did not see it for myself in the island of Stupido. Okay? The stupid island that is over there suffering from all of the stupidity. If I had not been there and seen them actually present documents with the last name, first name, middle name. So that's how you're going to present your bankruptcy papers. There is no more argument with the trustee of trying to prove. You don't have to give them a social security number because you're coming in as a non-individual. You see, what they've done is they've converted many of your papers when you guys have been filing, they've been converting you to an individual filing. That's why they want to see a social security number. That's why they want to have creditors meetings. Okay? And yes, if you have to bring in somebody, if you have to give somebody power of attorney over the estate, somebody you trust, then do that. Let them come in and represent the bankruptcy estate. Let them come in and represent the estate, especially if you have a spouse. Now, some of you, you don't want your spouse doing nothing like this for you because next thing you know, you're sitting up there talking about, I don't know how I ended up in here. Okay, and we don't want that for you. because some of your spouses, let's just say, for better or for worse, they, anyway, enough said about that. All right, that's this first thing. I just wanted to cover that briefly. Now, let's talk about, oh, I do see I have been read. Okay, let's talk about something else, something that's more important. Let's talk about the adverse possession. We have been doing adverse possession the correct way, but now we're going to do it the precise way. They want to play. These organizations, these courts, these judges, they want to play. They want you to bring it against a party. They don't want you bringing it against a property like they do all the time. Okay, so you're still going to put the name. Oh, and Tina, we're going to enjoin a party. Watch this as I pull this up. I want to show you guys. But you're going to put the name of the bank. I got to get rid of this, move this over so I can get to this. I just put in enjoin a party to a suit. Oh God, it actually has men's suits. God. Enjoining, legal definition of enjoin. So let's look at enjoining a party and its definition so you can understand. Those of you who have pending cases, you are going to enjoin a party. Now, some of you, I don't, and this right here has action to enjoin. So we might click on that next to give you a better understanding. Enjoin connotates a degree of urgency, as when a court enjoins one party in a suit by ordering the person to do or refrain from doing something to prevent permanent loss to the other party or parties. This type of order is known as an injunction. They're enjoining a party to stop them from doing something. Thus, you have the word injunction. Ladies and gentlemen, they say you learn something new every day. I did not know that's where injunction came from. And that actually surprises me. Then we go here. For a court to order that someone other than a specific act cease or cause of conduct or be prohibited from committing a certain act, to obtain such an order called an injunction. Now, enjoin, not the same as you're enjoining a party. Okay? But I do like the fact that we now know where the word enjoin comes from and why the courts use it. It is interesting to see that they have a root for their stupid words and where they come from, because we know the word enjoin doesn't mean anything about injunction. But you can see where ENJUNCT, injunct, would be somewhat correlated to this word right here. When you're enjoining a party to a lawsuit, there is a motion to enjoin, and it's not a motion for injunction. So we're going to do, since injunction starts with an I, injunction to enjoin, which makes no sense. But I want to do the motion to enjoin. And see, it gives us the same word up there, but I don't see, what is a motion to enjoin? And this person asks, can they use something like this? You're going to enjoin the bank. So what I want you to do is the bank and the servicer, you're going to add them. This site gets on my nerves. I only ask them a question, and to ask a question, you got to pay $5 to speak to an attorney. And, oh well, not for me. What is a motion to enjoin, and can I use something like this for issues of parental misconduct? Motion to enjoin is to ask the judge to order a party to stop doing something. See, they say a motion to enjoin, so let's do it with the I. And let's get rid of the E, because that may be my fault. I may never have recognized that it is two different words. with two different connotations. Nope, same word. That doesn't make any sense because I've done motions to enjoin all the time. And to have it not show here that it's a motion to enjoin, let's do it a different way. And I'm a demonstrator. So this is a motion to amend a complaint to add a party. So I just put add a party, but I want to see if it says anything about enjoining, and that's just for me, but I don't see anything about enjoining, and that is amazing because I am old school. I've been doing this for a while, and motions to enjoin a party, I've done quite often. You guys don't have to do a motion to enjoin a party if you filed your lawsuit or your adverse possession months ago. But if you just recently filed it, you'll do a motion to enjoin and you'll add a party. Okay? Now, this person put in a petition to amend the complaint to add a party. If you guys, I need to know, and you guys can unmute yourself to answer this question. Were you guys told to put does 1 through 1,000?
No.
Okay, that is an oversight on my part because when I do lawsuits, and let's see if I can show you an example. I just pulled up a case that myself and Tina had done, and I will apologize in advance. There has been a lot of things going on. Okay, there's been a lot of things going on, but when I do a motion, wait, I did tell you guys to put etc. all, right? After your name and after the party's names, when you guys put etc. all, you're adding all of the other parties. So I do know that I did tell you guys to put etc. all, and that's the reason why I would do that. But I'm looking for one of my documents that will say does 1 through 100, and usually on the original complaint, you will put does 1 through 100. Give me 1 second, because this is the paperwork that was filed in just one case. And these are all the documents that we are putting into the record, plus our fee waiver. And we're getting ready to make sure they understand about the fee waiver. I have to get their attention on that. There's a lot of documents. This is the entire file for all the paperwork that's in the case that we filed recently. Okay, so I don't think the original document is here. The original suit is here. But usually in the original suit, like the Defrauded Homeowners of America lawsuit, you'll see in that I put does 1 through 20,000. The reason why you put does 1 through 20,000 is so you can come in later and identify that party. So let's skip past that. Let's get you guys down to the nitty gritty. So let me open up the adverse possession template. And show you how to document.
Excuse me, Eon.
Hello.
Yes, I'm sorry for interrupting, but
No, you're not.
I clarify the word you're using. Are you saying the word those, THOSE, or
Does,
does,
DOES, like John Doe. So it's does, DOE apostrophe S, like John Doe.
Thank you.
Okay, I was going to do a writ of possession on another property and decided not to because not writ of possession, dang it, unlawful or adverse possession. I was going to do an adverse possession on another property, but we decided not to, and I'm glad I didn't because I wasn't thinking this way. But what you do is after you put the APN and then you put the, what's that thing called, deed of trust. Okay, You put the deed of trust number, and then the next thing you're going to put is the lender. Then the next thing you're going to put is the servicer. Give me a second. I will be sending a copy of this to you all. Not now. I have to update it so that it applies to you all. But I'll be sending a copy of this to you all a little bit later today. And so when you get it, let's get rid of you. When you get it, this is the format that you're going to put it in when you do your adverse possession. If you've already filed an adverse possession and it was dismissed, file it again. Okay? You're rid of adverse possession. You're identifying the lender. Okay? Remember, there is one other party that's not here that you're going to list. And then after you put the mortgage lender, DOE 1 through 6, and you're just going to call them DOE 1 through 6. The court understands DOE. It ain't that do, re, mi, fa, sol, la, ti, but they understand who DOE is. Then finally, you're going to put DOE apostrophe S 1 through 1000. And that's that. I gotta bold this and make it like the rest, so give me a second. I'm not gonna edit it here. I'm just doing this so that you all can see what you're gonna do. All right, now after you completed your caption, this portion up here is called the caption. You put the name of the court that you're gonna be doing this in. And then here, you're gonna complete the body, you're gonna complete the address, you're gonna complete all the other information. And I put in, I believe in this document, I put in all the information about the fact that there is no money. Okay, I put in the Banking Act information, and I believe at the bottom I must have put in all the different addresses. Yeah, the different lawsuits against properties. Okay, and I just hadn't completed it because the angle wasn't there. I've been thinking about this ever since probably about 2.5 months now, that I've been working on this, thinking about this, trying to figure out how to bring this about, how to make this work. So how do we make this work? Real simple. We bring it against the bank, especially if you're in possession of the property. If you are still in the property, you do it now. If they have not foreclosed, if they have not sold, you do it now. If they have sent you a notice saying they're about to evict you and you got to go to court, you do a countersuit in a different case. In other words, you go and file a completely new case against them for adverse possession. And by the way, I'm going to suggest that people file for adverse possession without putting in their mechanics lien. You're still going to file your mechanics lien. You still should have already filed your mechanics lien. But what you're going to do is you're going to put in for adverse possession in small claims court. Because adverse possession is a declaratory judgment request. So if you did it in small claims court, you'd be paying a lot less. But if it's only a judge that gets to make the determination, in some states like New Mexico, you have the right to a jury trial. So I would do it in small claims court and I would ask for a jury trial. Now, as I said, it is incumbent upon you to know the basic rules of the court. So download the rules of the court. So let's do that now. We're not going to download the rules of the court. All we're going to do is just pull up rules of the court for one court so that you all can see how the rules of the court are basic. Then we got one other thing to cover after this, and then that will be the end of the call. So what we're going to do, I do want this right here. This is a District Court of Pennsylvania. I download cases like this for my sake because of the case law and because of how the judge ruled. Judges are stupid, okay? They often say and do things Judges often say and do things that violate the law. So I pull up their case to get their opinion, and plus they quote from other cases I may not be familiar with. So I'll go through this document, I'll find a statement or something, and I'll use that statement from this point on. And because it's a recent case, it's going to give us that information. Let's see. Let's do New Mexico. Aren't you so special, Miss Cynthia? All right, New Mexico, rules of the court. Laws and court rules, New Mexico. Rules, New Mexico court. I'd rather go here. I don't want the statute and court rules. Well, the statute and court rules annotated. Now, that's actually something that will come in handy for me. Oh, it's unannotated. Dag nabbit. I looked past the un. If it was annotated, that means it includes case law. And so, if you can find annotated rules, I would most certainly say take a look at that. But this is New Mexico Civil Procedures Guide. New Mexico local rules. Then you'd have to go to the local rules for that court. I just did a video yesterday telling people about districts. New Mexico's courts are judicial district courts. California courts are judicial district courts. All the courts in America are judicial district courts. The reason that they're judicial district courts, and the word district only applies to DC. That word is, their word is patented. Now it says you should read all of them if you're not familiar with them. Why would I want to read all of them? This is the Court of Appeals. I don't want the Court of Appeals. I want the basic rules for the state. This is not it. This is the Court of Appeals. I don't want the Court of Appeals. It says New Mexico courts, then it says Court of Appeals. And it says court administration. The administrative office of the courts. Okay? Every court is administrative. I bring this to your attention because you need to know where you are. Every state has an administrative office of the court. In California, it's called the Judicial Council. You have a problem with the clerk of the court, ask them, where is the administrative office? And you complain to the administrative office. Mr. Hubbard can tell you what happened when we had a problem with the court and I contacted the administrative office. All of a sudden, everything changed. Okay? All of a sudden, they corrected their paperwork, refunded him back his money. Now, Cynthia, you're in the 1st Judicial District, aren't you? Or the 7th Judicial District? Cynthia. Okay, I'm gonna take it that she's in the 7th. No, she's not in the 7th. She's got to be in the 1st. The 7th Judicial District, that's Socorro County. This is Bernalillo County, so you're in the 1st Judicial District, aren't you? Huh?
We're in the 13th district.
Oh, you're in the 13th Judicial District.
13th district. Sorry. Yeah, 13th Judicial District Court.
Yeah, as you see, my screen won't let me do 13. As a matter of fact, it's stuck. So let me pull this page up again. Yeah, I wasn't sure, but I
Sorry,
knew.
it takes a little bit to unmute.
Okay. I knew for a fact that it wasn't, this is public record, so let's see if we can, and I did a video yesterday telling you guys how to complain against these judges who are causing you problems. So I would definitely take a look at the beginning of that video because it specifically talks about complaining against the stupid judges who cause you all of the problems, who sit up here and dismiss your complaint, dismiss your claim without reason, without rhyme. Okay, it ain't letting me get to where I need to get to. And I know that the video should have been uploaded already, the one that I did earlier, so that should be well done. So, oh God, it ain't well done. It's because I'm on time, so it's taking longer. Okay, I was getting ready to shut that whole thing down. All right, we can't do New Mexico because it's not letting me. So we're gonna go here And let's see if it's going to let me get to the 13th. You know, because I didn't even look. When I saw 9th, I was thinking 9th Circuit Court, 10th Circuit Court, 11th Circuit Court, so I wasn't even looking over on this side. I was wondering why, because I saw Court of Appeals, I was thinking those are the Federal Court of Appeals when I saw 10th and all that, so I wasn't even thinking about that. So here we are, the 13th Judicial District, which is Scandalous County. I call it Scandalous, but it's Sandoval. But Scandalous County, because it is New Mexico. Look at that, it's just not letting me go to the page. Let's do it differently.
Scandalous Davis.
Huh? What was that, Miss Cynthia? Now, mind you, I'm doing the Wi-Fi thing, and I'm on Chime. And I figured if I'm going to... Yes, go ahead.
I didn't know I was unmuted.
Oh, okay. Yeah, I thought you were commenting on the Scandalous County.
I was. I said the Scandalous Judge Davis.
Yes, Judge Davis, John Davis. I accused John Davis of having neck burn when I first was given him as a judge, and I don't think he ever liked me after that. Those of you guys who don't know what neck burn is, that's when your neck turns red, and John Davis really did come across to me. You know, I've never been to the courthouse in Sandoval. I didn't even know it looked like that. They spend a lot of money on these courthouses because what you guys don't know is that if you did the research, you'll find that your fees that you're paying, those fees are not necessary. You've already paid the fees and you don't realize it. When you pay for any taxes, you're paying for fees. Here we are, forms and rules. Rules and statutes. The reason it is necessary that I take you guys to this section here, hurry up. I shouldn't be impatient because I said I was uploading a video, talking to you guys, and recording the call. And it threw me off. And so I shouldn't be complaining. By the way, all the courts have an administrative office. And then you see the administrative office of the courts. Every court that you go to is administrative. What you guys don't know, and this is just for your knowledge, this is not for you to go spewing out and talking about in court, because then you are really looking at them making an example out of you, proving that you don't know anything. Okay? The first thing you need to know is there are 3 branches of government. Well, technically there are 4, and everybody has forgotten about the 4th one. The 4th one is the people, because it's supposed to be a government by the people, for the people, and other people. So the 4th branch of government is supposed to be the people. The 10th and 11th Amendment highlights that. Okay? However, you have the judicial branch, which is supposed to be where the judges are. Then you have the legislative branch, which is Congress. And then you have the administrative or executive branch, which is the governor or president. Okay? All corporations are registered under the administrative branch, the executive branch. Well, administrative courts are under the administrative branch or executive branch. They're not under the judicial branch. So you are not dealing with judges. This is the reason why they don't have to follow the law. This is the reason why they can violate the Constitution, because they're not obligated to go by the Constitution. They're obligated to go by what's called the Administrative Code. There was something that was introduced called the Administrative Procedures Act. It's Title V of the United States Code. This is what they go by. Administrative Procedures Act is administrative. It's executive. So the courts you're in, they're under the executive branch of government, not the judicial branch of government. We have been trying for years to get into the judicial branch of government and cannot find that access, but we're still trying. Now, New Mexico statute, court rules, and jury instructions administrative code. Check 2008 New Mexico statutes annotated, okay, 1978 to access statute, court rules, jury instructions. What I'm going to suggest to you is that all of you go to your basic rules. The rules are basic. Uh-oh, this page has been removed. Oh, do you know why they removed it? They removed the pages because they outsource it to companies, and these companies charge you. Okay, that's why it's not going to give us the annotated. See, unannotated, this site is not access to onesource.com. I don't care. Like I said, they outsourced the site to a different company. And so we're going to go to, and I'm so sorry that I have to take you, get a document about citation, targeted search, specific database. I just need the stupid rules, people. And you're going to have to go through similar stuff. So I'm going to click on this to see if it will take me there. And I'm just looking for basic stupid rules, and it's not giving me the rules. Okay, rules of civil procedure, district court. This is where you will go, Cynthia, for finding the rules. So we are going to I have to do this. You shouldn't have to do this. But what this is commencement of an action. I just put filing. Commencement of an action, service of process, meaning serving the other party, your pleadings, what they must consist of, motions and orders. Then it says commencement of an action. It will basically give you all of the things involved in commencing or starting an action. And this is the actual rule. A civil action is commenced by filing a complaint with the court. Upon filing of the complaint, the clerk shall endorse thereon the time, the date, the month, and the year it was filed. Pay attention to their use of the word endorse. Many of you thought the word endorse had something to do with a signature. An endorsement is a statement. It is not a signature. It never was. But to keep the people where they are, they have been led to believe that an endorsement was just their signature, so that when they're signing things, they just put their signature thinking that's enough. Now, Cynthia and the rest of you, you need to go over these basic rules. What are the ones that you need to go over? This one, this one, this one, this one, this one. You can skip all of this stuff. This one, you can go over time too, because it's going to let you know the time and things and motions and how presented. Yeah, I would suggest you go over this. Now, let me make sure, and we're not talking about arbitration, pretrial conferences, scheduling and management, party, plaintiff, defendant, capacity. Not really, but we're going to click on that. Because some of you are thinking that this is a lot of stuff to go over. Come on now. This is not a lot of stuff to go over because it's only a page. And some of them you're going to find is probably going to be one sentence like the other one. It's not a lot of stuff to go over. You don't have to study all day. But you need to have a basic understanding of what's going on, because when I talk to people, people are asking me this and they're asking me that, and I'm thinking, wait a minute, that's right there in the rules. That's the basic rules. You need to know what the basics are. This is jury trial in civil actions, especially New Mexico. In their small claims court, you have a right to a jury trial. You want to be before a jury. You do not want to be before a judge. You've already been before a judge. You never want to be. See, a jury of either 6 person or 12 may be demanded. You have to demand a jury trial on your original pleading. So when we go back here, oh, you finally opened up. Well, you got to go and cancel and minimize you, and give me a second to open up that claim of adverse possession. Jury trial demand. You have to demand a jury trial. Okay, it has to be in the original pleading, original caption. If you fail to do this, then they will deny you your right to a jury trial, and a judge will make the determination. If you get a judge that says, well, you didn't request a jury trial in your original pleading, you say, excuse me, I apologize, but yes, I did. And if he says, no, you didn't, and you didn't, you say, oh, well, then I withdraw my complaint. Thank you. You all have a nice day. And you walk out. Because if you don't withdraw your complaint, he will dismiss it, and he will more than likely dismiss it with prejudice, meaning you can't bring the complaint again. But you always demand a jury trial. Some of you think this is too much. I won't be able to handle this. They're going to do this and they're going to do that. So let's go back so you get it, and then we're going to talk about the pay to the order of stamp for those of you who have current mortgages now, so you can get rid of that junk now. So that's the last thing we're going to talk about. Let's get back here. Some of you think that when you get these responses, I don't know why it sent me here since we were already on this page, the page that I just highlighted. Let's do commencement of action. Oh, like I said, some of them are just one sentence, so it's not a lot of studying. Okay, we already been here, but when you are responding to these idiots, when they put in a motion and it's like 20 or 30 pages and it's got all this case law, do not worry about that. What you put into Google, how to how to respond to a motion to dismiss. Okay, and now you just typed it in Google and somebody will explain to you how to respond to a motion to dismiss. Now, some of you live in certain states where they call a motion to dismiss a demur. If an attorney puts in a motion to demur, then you put in how to respond to a demur motion. And you ask Google. Then you come and ask me. Because I'm going to make sure that if you come my way, you have a little bit of knowledge first. So I'm not explaining to you all of the elementary things that you can learn for yourself. They say knowledge is power. The more of an understanding of this you have, the better off we are when I am helping you with this, so that I don't have to spend so much time explaining the basics to you. So yes, you're going to have to be invested. The same way as those people when I was a young boy told me, no, I will help you, but you have to go do this first. I will give you, his name was Richard Fuller, and I believe Richard is no longer with us right now, but Richard was a rocket scientist. I kid you not. He was literally a rocket scientist. And Richard Fuller saw me and heard me speaking, and he pulled me to the side and he says, I got something I want to show you. And what Richard Fuller showed me was the First Amendment. Told him, I know that. Right to speech, right to assemble, the right to the press. I said, freedom of speech, right to religion, the right to freedom of the press, and the right to peaceful assembly. I know that. He says, well, what is this? Then he pointed out the right to petition the government for redress of grievance. And I looked at him. I don't know. He says, well, go do some research and then come back and talk to me. When I did the research, I went back to him. I said, it's still not that clear. But redress, I looked at it, it means to correct the wrong. He says, yes, you have the right to petition the government for them to correct the wrongs that were done to you. Really. Every constitution in America has it. Every constitution in America must recognize your right to petition the government. That's what I learned on my own. All he did was gave me a little nibbit. He gave me a little crumb, and I took that crumb and I sustained myself from it. So I'm doing the same thing for you all. I'm showing you that filing a lawsuit is not that hard. They want people to think it's hard. It is basic, it is simple. It's just these lawyers go to school and they put in all this junk and they put in all this memorandum of laws and you guys don't have to do all of that. On appeal, they want you to file this document, that document. So if you have to, let's see, and then we'll go on after I do this thing. I'm trying to think of one thing that you have to file an appeal in federal court, because some of you guys end up in federal. AMPLE. One document, TICE, federal appeals. I'm thinking of one document that I know that has to be filed, and one of those documents is called one document. And it was difficult for me because I couldn't think of any other document that needs to be filed, but sample. Sample interested party notice. Notice of one party, no, not looking for that. A party in the case shall file a notice identifying all cases pending. Okay, notice of related cases, that's not what we're looking for. There is a interested party notice that needs to be filed on appeal. But as you can see, you put in whatever document you're looking for that the court requires, because their rules are going to say you need to do this, you need to file this, you need to file that. The first thing you do, even if you have to file a brief, sample brief, appeals court, and you type in sample and they will give you sample. And this, we get the local rules of civil procedure for the state of Colorado, and it will list these things. This is how you get started, okay? And this tells you what you will need. You just have to understand, you think that these rules are complicated because it looks like a lot. This is not a lot, because you don't have to really do too much studying of this, because once you understand it on the state level, it's going to be the same thing on the federal level. Sorry, ladies and gentlemen, I gotta, hold on one second. Sir, I need you to say hello. Say hello to everybody. Ladies and gentlemen, that's Alaric Scott. He's calling us almost from his house. So I wanted to let y'all know that Alaric is up and about. Those of you who didn't know, I'll tell you later. Alaric, we're doing adverse possession. Can I give you a call back as soon as we finish this conversation? All right, sir. We'll talk in a minute, all right? All right, goodbye. I couldn't tell y'all ahead of time, including Kyle, but Alaric did adverse possession on a property, and he did everything right. But he also was doing an adverse possession on another property. And when he did an adverse possession on another property, it belonged to a very influential individual. This influential individual got the state county attorney, the state and the county attorney, to go after him. And they were claiming that he falsified documents in the record, where he didn't falsify anything. The documents all are 100% legitimate. They all have the right seals. They all have the right information. But they decided to come after him. And so the judge had a hearing a week and a half ago. And at the judge's hearing, the judge specifically told him, all right, we're going to start trial on the 6th of November. 2 days later, they had another hearing. And they said he failed to appear. He was already out on bond. And they said he failed to appear, so they arrested him. That's why you guys, we haven't had many meetings, because I've had to pick up the slack from what Alaric wasn't able to do. Okay, so we've done some paperwork. Yesterday, they reduced his bail, and he was able to bail out. And so now I go after getting that case dismissed for him. So I just wanted to let you guys know that, and that's why I wanted him to be able to say howdy to those of you who did know that that had happened to him, to let you all know that he was okay. All right, so some of you, that was a surprise because you knew what he was going through, but you didn't know what was going on. I've known he was getting out this morning for about 3 hours now. I just wasn't going to tell people until it happened. All right, that's enough about that. That's enough about the court. That's enough about what you all need to file. Now let's focus on that one document that I did a video on yesterday. If you didn't see the video, I did 2 videos in a row which talked about the pay to the order of stamp. That's this bad boy right here. This pay to the order of stamp, ladies and gentlemen, this one has the box around it, and I made these words a little bit more prominent because I want it to look like a stamp. So let's enlarge this for you so that you can see it. Now I'm going to do the same thing with you all that I did on video. I'll send, as a matter of fact, let's do that. Give me you, and we're going to put, wait, Cynthia, what did you say? No, I don't want you to amend your original adverse possession. If you're having problems right now and they're giving you a hard time with the original adverse possession, because all of you who filed the adverse possession, the way we did it, that adverse possession should have been over. But if they're giving you a hard time, you're going to go back in, you're going to withdraw your complaint. You're going to put in a motion to withdraw complaint. You're going to file that with the clerk of the court. And you're going to put without prejudice. So no, don't even put without prejudice. Just going to type up a motion. Let's give you a simple motion so that you'll understand what you're going to do. Simple motion. The name of the case, you're just going to make a copy. Just take one of the motions, open it up in Word. You're going to take your mouse and you're going to do this. This is a long one, so it's going to take a minute. No, it's not going to let me do that. Yeah, this is going to take a minute. So basically, you're going to select everything and you're going to delete it. So that once you delete it, whatever it is, you're going to have the blank space without the numbers. I'm only doing this to give you an example. So let's give you that example so you can see that. Okay, once you've deleted everything on the motion that you're going to pull up, then you're going to put in right there, petition to withdraw. No, don't even put petition. You're going to put in notice of withdrawal of complaint. And then in the next line, you're going to put I, whomever. No, you're not going to put whomever. You're going to put I, you're going to state your name. Hereby, willfully, I should have been here. But anyway, willfully and deliberately withdraw my complaint, effective immediately. And that's all you're going to put. Cynthia, you're going to do the same thing. Those of you who filed adverse possession and it's pending, you're going to put in a motion to withdraw your complaint intentionally and willfully immediately. Okay? The reason why you're going to do that is because you're going to refile that complaint and you're going to file it the correct way. I know you spent some money. I'm trying to save you a headache and trying to give you a shortcut to get past all of their stupid stuff, because it is stupid what they're going to do to you. And I don't want that to happen. Okay? So, to keep that from happening, you're going to do a motion to withdraw your complaint effective immediately. And you're going to withdraw the complaint. You're not going to wait for the judge to dismiss it. Oh, this was supposed to be the lender. Okay. Let me see. Who am I talking to? Miss Tina. That's what you're going to do with that case with that stupid Judge Wilson or whatever his name is. And we're going to go back into that court, go back in with that bank. Now, let's get back to the stamp that I have to put in. You guys, I need you to understand. Remember, I'm not looking at the screen. You're seeing my screen the same as I. So when you type into this, it'll be better if you spoke up. Jennifer, nice to see you. How are you doing today?
Well, I just finished the creditors meeting, and they scheduled me to come back to see the judge in the 6th, I think, and then December the 6th. And then there's a 13. He said if the judge does not dismiss it, I need to come back to see the trustee, and he denied that he's a trustee for the debtor.
Don't worry about that. Don't worry about what he's denying. Okay.
And so he keeps trying to get me to admit. He's trying to trick me many times to admit that I'm the debtor. And so I keep pointing out that the debtor is a non-individual. I'm a living person. I'm a private person.
Stop telling him you're a living person. Tell him straight up, I am an individual as defined by statute. The debtor is a non-individual as defined by statute. See, when you guys use terms like living person, living individual, they're going to associate you with those people out there who do videos and who follow that stuff and who get psych evaluations, and you don't want that. You want to avoid that. Okay?
Okay.
And that's how you're going to do that. But no, everything went okay. The trustee is recommending that the bankruptcy be dismissed, correct?
Yes, but then he said he just received a notice that I need to go to court in December the 6th.
Exactly, which he's still going to put in his recommendation, but what's going to happen is you're going to tell them what we talked about at the beginning of this video. So when you receive a copy of this video, that's going to be your argument. So you're going to be going over this particular video. Guys, the pay to the order of stamp and endorsement, and thank you, Jennifer. I just put in the pay to the order of stamp and endorsement. So go ahead and take a look at that, because you don't have to open it up now, but I would download that because I probably won't remember to send it to you. The way this stamp works, let me get rid of that box. The way this stamp works is the law. The law says that the holder of the insured note shall endorse the insured note as follows. Pay to the order of the United States of America without recourse. You're going to, and I know some of you have already done this by hand, and that's okay, but I would prefer you take this stamp. The way this stamp works is it's on this page. You will get your original page. Let's say, oh, come on now. Let's say this is your original page, and let's say you want to put the stamp here. Okay, let's say this is the space where the signatures go, and I want to put the stamp here. So what you're going to do is you're going to go back to this page, and you're going to come here, and you're going to take the stamp, and you're going to adjust it to where it should be. You're going to print up a blank page. You're going to put the blank page over your note where the signature is supposed to go, and you're going to see that it should be lined up. If it's not lined up, you'll do it again. You take the same page, put it back in the printer. It already had the stamp on it. You put it back in the printer. You're going to put a mark on the page that has the stamp that you just printed. Trust me on this. When you print it up the first time on that blank page, you're going to put a mark, put a number 1 or a mark or something. You're going to take that page after you do the adjustment. Let's say, I know this is just about the area it should be, but let's say I'm a little off. Let's say it should be up a little bit. So I'm going to move it up a little bit. I've already put a mark on the first page. Now I'm going to print it up again the second time, but the second page I'm going to put it in the printer, and I'm going to put it in upside down. Okay? So that when I print up the second page, I put it over the note that has the signature, and I see that it's lined up. This is designed to where the white space on this doesn't print. The only thing that prints is all the colored areas. The black line, the black information, none of the white area prints. It will print right over your document. so that the lines that are already there remain there. That's how this is designed. So the only thing you need to do is take a copy of your note, make 5 copies, trust me on that. Make 5 copies of the signature page of your note, not 5 copies of your note, not yet. Then you're gonna put it in your printer. Usually if your printer is like mine, if it goes through the printer and comes up and comes out of the feeder, then you're gonna put it in face down. That way it'll print on the faced up part. If your printer is one of those printers where you just stack the papers, then you're gonna put the paper in face forward. Because when it prints, when it goes through the machine, it prints face forward, okay? And you're gonna print this on the page. You're gonna do 1, pay to the order of the United States of America. Now, if you notice, the United States of America comes with the underline. You're gonna go, I need to make this smaller so we can all see it. And let's say if it's Bank of America, so you're gonna put Bank of, now I just typed that in because of the font I'm using, it's already all capital. You're gonna put Bank of America, comma, NA. NA doesn't mean non-applicable. NA stands for National Association, period. And then sign the name because you're the authorized agent. So after you sign authorized agent, oh, sorry, wrong button. Make that line a little bit longer. After you sign authorized agent, it already has without recourse. That's all you have to do. You do 2 to Bank of America and you do 2 to the United States of America. You label at the top, one of them will be labeled, one of your notes, you're gonna handwrite the word either 1 or A. And on the other note, you're gonna handwrite, because remember, it's not on a blank page, it's actually on the note. After you put this on there, you're gonna print up 2 copies to the United States and 2 copies to Bank of America. You're gonna label one A, you're gonna label one B. You're gonna label the other one A, you're gonna label the other B. Does anybody know why you have to label it A or B? Come on, people, work with me. Nobody wants to answer? Why don't you answer and take the chance on being right? *7 or hit the mic button to unmute yourself.
To identify that they're separate endorsements?
Well, no, not that they're separate endorsements. There's a reason for it.
One's the original, one's a copy.
Nope. But
Put one in the corner and one each.
okay, now I'll give you the answer. And I want to thank all of you for at least attempting to answer that question. It wasn't complicated. It's all in the wording. Remember, you're making 2 to Bank of America, and you're making 2. Go ahead and mute yourself. You're making 2 to Bank of America, and you're making 2 to the United States of America without recourse. Ladies and gentlemen, what happens if you make 2 checks payable to the United States of America and they have the same information? Or 2 checks payable to me and they have the exact same information? One's considered counterfeit. You cannot have duplicate items. They have to have different numbers on them. Duplicate items mean that one of them is a counterfeit. That's why you can't have $2 bills without it being 2 different serial numbers on those dollar bills. Okay, answer to your question at 11:02 is yes. Okay, now, are there any questions? This is the information I wanted to give you all. This is the information I've been wanting to give you all for more than 2 weeks.
Yes, Leon, can you hear me?
I can hear you.
On that promissory note, if there's 2 parties on your promissory note, you should put a line and one right below it and then sign it.
No, because the note only needs an endorsement. Now, if you want to do it for both parties, go right ahead, and you're doing it as authorized agent. So if you want to put 2 endorsements, but take a look.
Oh,
If you look at the promissory notes of people who have 2 people on the promissory note, it's actually a good question. If you look at the promissory notes that have 2 people on that promissory note, you see that the bank, when they do pay to the order of, they only do 1 endorsement. Take a look at the code. The code says that the holder of the endorsed note, the holder, shall endorse it. Okay, but originally you are the holder of the note. That's why you have the right to endorse that. You are the one who's supposed to endorse the note originally, pay to the order of. So you can do it for both persons, or you can do it for one. The code only requires 1 endorsement. It does not require 2. So if you want to give them, it's called a dual or double endorsement. If you want to provide a double endorsement because there are 2 names on the note, then you by all means provide them their double endorsement. Okay, so the answer to your question is, it's a legitimate question. The answer to your question is, it is up to you to determine whether or not you want to do the dual endorsement. But they understand what a dual endorsement is, and dual endorsements have a little bit more weight. Okay, I have somebody who received a check in his brother's name. His brother gave him the check, and his brother signed the check, and he signed the check. He took it to the bank, and the teller says, excuse me, sir, give me 1 second. And she goes back and speaks to her manager, and the manager and her comes to the desk, and he says, do you have ID, sir? And he gives him the ID. He says, okay. She says, sir, what are we going to do? He says, we're going to cash it. It's a dual endorsement. And they cashed the check. He said dual endorsement. So they understand that terminology. Okay, any other questions? Any other people? Any other party? Any other body? Yes, Jennifer.
Yes, I have a question. Since the loan originally with Bank of America is a long time ago, they sold it several times, that it's still okay to send it to them?
No. You do it with the current lender.
Well, I don't have a current lender.
Yes, you do. You have to call the
servicer.
No, you call the servicer and ask them who the lender is. The servicer only services the loan on behalf of the lender.
Okay.
So you call the servicer and ask them who the lender is. Now, if you want to do it for Bank of America, you can by all means do it for Bank of America and say that you tendered payment to Bank of America and that their dispute is with Bank of America. And you can bring that into bankruptcy court. You can bring your endorsed note into bankruptcy court with that code saying, I've already tendered payment on this property on behalf of the non-individual. We're not going to call it an estate anymore. We're going to call it a non-individual.
Okay.
Okay.
Also, the endorsement there, should I also put for deposit only?
No, God, no. You're the second person to ask me that, and for the life of me, you do not want to do that. You never want to put that on a mortgage note. When you put for deposit only, you guys don't realize you're doing what's called a restrictive endorsement. I gave you guys the note on what tender is. When you do a restrictive endorsement, they can literally refuse. They do not have to accept it. So you don't want to put for deposit only. I gave you that stamp. That stamp is complete. You don't have to add nothing to it but a signature. And if it needs to be to the lender, you correct that name. But that stamp is complete. You don't have to add anything to it. Okay? So no. I want you all to understand that other stuff that you may have heard people talk about, even stuff that I talked about on videos in 2012, leave all of that stuff out of this. That has nothing to do with what we're doing now. Okay? That has nothing to do with what we're doing now. But yes, for deposit only, oh God, heavens no. 2 people have asked me that question in the last 2 days, and I, for the life of me, I'm saying don't do it. So no okay. For deposit only.
Thank you.
No problem.
Thank you.
Okay, who'll be nexty?
I have another question.
What's your question, Daniel?
If another party had claimed to have purchased the property, do you still do this?
Yes, you still do that. Oh, I'm sorry, ladies and gentlemen, let's schedule another conversation for next Saturday. Not this Saturday, next Saturday. I'll get the time number to you. We're going to talk about the when we have, like in Daniel's situation, when we have another party who comes in, you have to do your background noise, Daniel, because it threw me off a little bit. A lot on my mind today. Ladies and gentlemen, in Daniel's situation, another party has come in claiming that it purchased the property. Remember I told you we're going after the mortgage insurance company? Well, when you do your adverse possession, even if you're out of the house, we have 2 people whose houses have been taken from them over the past 5 months. Okay, what you do when they come in and they take your property, what you're going to do is you're simply going to do a lawsuit against the insurance company and the lender. Remember, your property has mortgage insurance. What you all don't know is after they kick you out, they apply for the insurance at par value. When you go after the insurance company and you go after the fact that you made payment because you're going to show that you tendered payment in the form of that endorsement, you now get to pull in their records, their financial records. They're never going to want to show you their financial records on the property, but you got to understand you have a right to that information, so you subpoena it and you do what is called a motion for discovery. And you send in your discovery request. You put in discovery request, you send it to the other side. If you got a case going on, there's a party you're going against, put in the discovery request. After you put in your discovery request, after 30 days, if they do not give you the discovery you're requesting, then you put in a motion to compel discovery. Okay, it's all right there in the rules. Once you do your motion to compel the discovery, you're asking for the financial records because you've already tendered payment. Okay. Is there another question from anyone else? Someone else? The same persons, the same parties? Somebody?
I have another question.
Yes.
Since you were talking about the adverse possession and different ones that you put as defendant, now what about the title company? Because they didn't really do a good job in my case,
yes,
I don't think.
But you're doing an adverse possession, and that's for the property. You can bring the title company in as a witness. You can bring in their information as evidence, but going after the title company to adverse, they're not claiming to own your property. That's why you're not putting in the name of the servicer. You're just putting in the mortgage insurance company and the bank. But you're going to have to go back and listen to the first part of the video because that's where we talked about that.
Okay, thank you.
What if someone is deceased that's on the note?
I would suggest, and now look, you have power of attorney. I was going to tell you that when we talked again, but you have power of attorney for the deceased party. So you can do the dual endorsement and you can sign his name because you have the authority to sign his name. And remember, we're not putting dates on this. Okay? And if you're like me, look, when I was 10 years old, my mother had 7 kids. So when I was 10 years old, there were 7 of us in school. And my mother, if we were absent from school, my mother did not want to write 7 different absence slips. So she had us write our absence excuse, and she had us sign her name. To this day, I sign my name almost exactly the way she signs hers. So if you're husband and wife, I know you know how to sign the other spouse's name. If you don't, shame on you. So by all means, if the party is deceased, we're sending this to them, and you can put in your cover letter that you've already sent them the endorsed note. And you can tell them this was sent initially, and you can tell them the date that it was sent. That code has been in there for over 50 years. And when you look at the bank, when they endorse a note, they don't put a code on it. But you can let them know, I sent this to you guys some time ago. And I believe you've already received the treasury check at par value. However, since the records indicate that you are still claiming that you have not received the treasury check, here is the endorsed note, a copy of the original one, being sent to you a second time. And you send it to them with that original signature. I can't tell you guys what to do. I can only tell you, I hope you understood what I just said, or overstood what I just said.
I have another question.
Yes.
Since the original note that I signed of course, I only got a copy from the title company.
It's
And
okay.
they send the original.
It's okay.
They send the original to the bank. And then, of course, now with that, I would just kind of make another copy, but it has my signature and already in a copy.
It's okay. Do you understand?
It's okay?
Your signature is going to be in the endorsement. When the bank sign it, it's okay. They don't need to have the original. You guys must understand, what makes something an original? Does anybody know? Does anybody know what makes a document an original document?
A signature.
A signature. So now that you do the endorsement, it's going to have an original signature. That's going to make it an original document.
So what about a date? The date is, it's years ago.
No, what do you mean? We just talked about that. What about, there's no date on the endorsement.
Okay.
There's absolutely not one single solitary date on the endorsement. You following me?
Yes, thank you.
So it doesn't need to have a date. Don't you dare put a date on that document. So don't put no dates on the document, people. Okay. Is there anyone else?
Yes.
Okay, Daniel, what is your question?
Okay. I think I tried to ask this the first time. When you have two signatures, is it okay to have two lines there between the paid to the order of and without recourse?
Why would you need
two signatures?
Why would you need no? Why would you need another line?
If you're going to sign somebody else?
Then you put another endorsement and you put the other stamp, but that's exactly what I said earlier.
Oh, okay.
You can put two lines there if you want. That's okay. That'll be your dual endorsement. You can put two lines with two signatures. That'll be your dual endorsement. You don't actually need two stamps. So your question, again, not a bad question. And Tina, and those of you who have two people on your note, if you want to, this is what he's saying. Some of you guys may not be getting it. So I'm going to show you what he's actually saying. He is saying this right here. He's saying, is it okay to have this? But if you're going to do that, give me back my highlight. And then we go up here. Then we go here, and I do no spacing, and I do that. I'm going to have to change that font. And, okay. Yeah, I'm going to have to change this font later. But this is just a sample example for those of you. Oh, come on now. All right, this is just a sample example for those of you who are watching. But Daniel, if you were to do something like this, then yeah, that could work. So if it's a, trying to see which one did I use. No, that's not the one I used. It's got to be this one. Yeah, that's it. Was trying to see which font I use so that it can be uniform. All right, let's do, Daniel, I'm gonna do you a favor. Give me a second, everyone. Endorsement stamp was right by each other, huh? Yeah, let's put dual first before endorsement. Okay, so this one I'm going to save as dual endorsement stamp. I'm going to put that in Chime right now. And now you have your dual endorsement stamp for your promissory note.
Eon, don't you need to put the words without recourse under each?
No.
Because you put authorized agent under the first line, but
You
then
better
on the
believe
second line it says
And both of
authorized
them,
agent without recourse.
pay attention. You see this right here? Can you tell me what this is right here?
Authorized agent signature. And
No,
then
no.
the bottom
This.
one, authorized agent.
Are you seeing the screen?
Yes. Page
Okay,
the order of Bank of America.
No. Can you
only.
tell me what this is right here at the beginning?
A quote.
A quote. Can you tell me what this is right here at the beginning?
Oh, and then we've got it at the end.
Okay. So what does that quotation mean?
It includes all that information.
It includes it. So there's no reason for me to put authorized agent without recourse, authorized agent without recourse. However, if it's a dual endorsement, if you want to put signature without recourse, you can. As a matter of fact, let's do you that favor. Let's do that. Let's go ahead and do without recourse. And watch this, because there can be two holders of a note. So we're going to put our space and we're going to put without recourse. And let's just put without recourse underneath. Yeah, it's moving ever so slow because of the system's resources. Come on, chug-a-lug. Okay, so we're gonna save this. Give me a second. And Daniel, I'm gonna send it to you. It's okay, but as I told you, it wouldn't be necessary to have two paid to the order of without recourse. But what we're gonna do is we're gonna put that one in. I'll give it to you this way. So make sure I save it and get rid of that. And I'll put it in Chime now. Now, these are details, even though I did a video telling this stuff to people, these are details that we did not discuss in those videos. Okay, so there you have it. I would go ahead, because once we close this chat, that the information that's in this little section here will not be there. So if you guys haven't double clicked on it and downloaded each of these items, I would say do that now. I will try to put it in the email, but a lot's going on, so I may not be able to do that. So I would suggest those of you who have access, you're on your computers, download the information now, and you'll be better off.
One more question.
I have a question that could be answered. One more.
Okay, you said on, I understand, do not put a date on the endorsement, but the letter, the cover letter that goes with it?
Yes, you're doing a cover letter. You can put a date on that.
Okay.
You guys, you all should know me by now. I am very specific. So especially when I say something about do not touch that endorsement. Okay, do not add dates, do not add for deposit only, do not add payable on demand, all of that stuff, leave all of that junk off of that endorsement. But to your cover letter, that's your cover letter. You get to let them know in that cover letter. And that's why I say you can tell them in that cover letter that you have previously sent them an endorsed note, because it was your intention to endorse the original note. So you would not be lying or misrepresenting the truth, but you previously sent them an endorsed note, hoping that they would comply with the policy. But it appears that they have not forwarded your endorsed note to the U.S. Treasury. So you've taken the liberty of sending the United States Treasury a copy of this endorsed note and a copy of the endorsed note, comma, and that it would be your hope that they would apply to the Treasury for their payment at par value as prescribed by the accompanying statute. And then you put a copy of the statute there. You have to figure out how to word the note. And yes, I know some of you are going to be so nervous because you're thinking you're not going to say the right thing. Go back over this video. I've already told you everything you should be putting in your cover letter, and your cover letter should be less than 2 paragraphs. Your cover letter, the body of it should be less than 2 paragraphs. And when you send in that cover letter, don't put your signature on it. Just sign your name. Type your name and send it to them, because your signature is already on the endorsed note. You're only endorsing the note. Now, some of you, pay attention, you can endorse the deed of trust if you'd like. Pay attention. You can endorse the deed of trust if you'd like. You can put the same endorsement on the deed of trust and send it along with your note. Okay, can I promise you that they will respond? No, I can't. But what I can promise you is when you go into court and they want to try to kick you out and they want to try to go through foreclosure proceedings, this is how you handle their foreclosure proceedings junk. Okay? Now this video that I'm doing, we've been talking for an hour and 47 minutes. That hour and 47 minutes is going to make this take a little time to upload, but you guys will get it within the next 3 hours. Okay, at least that's my hope, because it's a lot of systems resources and the signal here is not all that great. Okay?
One more question about adverse possession.
What's your question?
Could you add the party that claimed to own the property or purchase the
No,
property?
Daniel. No, Daniel. No, Daniel. You can only do an adverse possession on when you're doing the adverse. See, your situation is different. You're already outside of the property. Okay? You can only adverse possession a property that you're in possession of. That's the first thing. What you're going to have to do is what's called quiet title. And you do quiet title by going into court saying, hey, I own this property. The property was properly endorsed. They received payment. I had mortgage insurance. So your angle is quiet title. Yes, I get what you're saying. I get what you're saying by adding the person's name because they're in the property, they're in possession of the property now. You can, here's the thing. You can try to adverse possession a property where somebody else is in the property. There are two of you who have that situation. You can actually go about trying to do that, but the judges are not, they're not acting correctly. They're acting stupid. Okay? And because they're acting and being stupid, that's our problem. They are the stupid ones. Okay, so they'll give you a hard time with that. So that's why my answer to you was no, no, no. They will tell you exactly what I just said. You can only adverse possession of property to which you're actually in possession of. But if your adverse possession process started before that person took over the property, then yes, you can always adverse possession that property. If I was you, I would just go back and refile that adverse possession. Okay, the problem is you'll have the bank saying they're not owners of the property. So if I was you, I'd go back and refile the adverse possession, but I think you'll have a better chance on going after your original adverse possession when you brought up adverse possession against the property, put it in that case, which means it was already against that individual, already against that so-called company. We already set you up for that. So, but we'll talk about that separately than this conversation, about what your options are in your situation. Okay?
Okay.
All right. Ladies,
Thank you.
gentlemen, yes, you're welcome. Ladies and gentlemen and ladies, we're going to go ahead and let all of you go. I'm going to stop the recording now.